Good evening, I'm Marjorie Schuett. Tonight's forum is presented by the League of Women Voters of Dane County, of which I am a member. The League of Women Voters is a nonprofit, nonpartisan national organization whose purpose is to promote informed and active participation of citizens in government at all levels. The League takes no position on candidates or parties. It does advocate for issues, however. The League's vision for the courts is a system where everyone in Wisconsin has equal access to fair, unbiased courts and are insulated from the corrosive impact of partisan politics and special interests. This forum is being recorded and will be available on our website, lwvdanecounty.org. Captioning is available. Historically, the spring elections in Wisconsin have been quiet, low turnout affairs. This year is different. The national news media is calling Wisconsin's spring election the most important election in the country in 2023, and likely the most expensive Supreme Court race held ever in any state. Tonight's forum is the second of three presentations intended to educate our members and the public about the issues and choices to be made in these elections. The first forum was entitled, State Constitution, Are Changes Necessary? A recording of that forum can be found on our website. Since the time of that forum in January, we now know that the April 4th ballot will have two referenda that would change the state constitution. These referenda were discussed at the first forum. One concerns cash bail before conviction, and the other concerns conditions of release before conviction. The State League of Women Voters opposes both of these changes to the state constitution because they will likely result in more persons being detained prior to being convicted and will likely increase the costs at our local jails. There will also be a third referendum that concerns work requirements for those receiving welfare benefits. The State League opposes this non-binding referendum because the work requirements already exist in our state law for persons receiving food stamps and unemployment benefits, and because work requirements in Medicaid are no longer enforced. The third forum will be held March 9th and is entitled Judicial Integrity, Should Judges Decide Cases Involving Their Major Campaign Contributors. Tonight's forum is entitled Wisconsin Supreme Court, Why Your Vote Matters. The League of Women Voters Dane County begins each of their programs with a land acknowledgement, recognizing that Indigenous peoples are the original stewards of the land we now inhabit. Then our speakers, Professor Rob Yablon and attorney Krista Westerberg, will review recent Supreme Court decisions and discuss their impact on Wisconsin voters. And in the last half hour, the speakers will address your questions. You can enter your questions at any time in the Q&A section on your screen. First, the land acknowledgement. In owning our past and charting our future, we, the League of Women Voters of Dane County, recognize the Indigenous peoples who are the original stewards of the lands on which we now live, while we struggle to learn more about the current and ongoing context of colonialism. In Dane County, we are all standing on the stolen ancestral lands of the Ho-Chunk people. We pay respect to their elders, past, present, and future. Please take a moment to consider the many legacies of violence, displacement, migration, and settlement that bring us together today. Thank you. And now on to our speakers. Robert Yablon is an associate professor of law at the University of Wisconsin and faculty co-director of the State Democracy Research Initiative. His research interests include political and election law, constitutional law, federal and state courts, and statutory interpretation. Professor Yablon has recent publications that have appeared in several law reviews. The professor received his bachelor's, excuse me 1 minute while I get my voice. He received his bachelor's degree in economics and political science. Hang on 1 second. From the oh boy, hang on. Professor Yablon received his bachelor's degree in economics and political science from the University of Wisconsin-Madison and his master's degree in social policy from the University of Oxford, where he was a Rhodes Scholar. He then earned his law degree at Yale Law School, where he was an articles editor of the Yale Law Journal. Following law school, Professor Yablon served as a law clerk for Judge William Fletcher of the U.S. Court of Appeals for the Ninth Circuit and for U.S. Supreme Court Justices Ruth Bader Ginsburg and Sonia Sotomayor. Krista Westerberg is a partner at Pines Bach, a Madison-based law firm. She is in their litigation practice group. While experienced in a variety of civil litigation areas, Attorney Westerberg concentrates her practice in open government law, as well as environmental and land use law. Attorney Westerberg is a co-vice president of the Wisconsin Freedom of Information Council and a board member of the State Bar of Wisconsin's Administrative and Local Government section. She graduated with a Bachelor of Arts degree from the University of Missouri, summa cum laude, and from the University of Wisconsin Law School in 2002, cum laude. We're now going to go to the speakers' presentations. Attorney Westerberg will start us off with an introduction to the Wisconsin state court system. And Professor Yablon and Attorney Westerberg will then highlight Wisconsin Supreme Court cases from the 2021 and 22 session and discuss their impact on Wisconsin. Finally, the speakers will discuss what we can expect in the future. Attorney Westerberg, I'll turn the program over to you. Thank you so much.
Thank you. Can you hear me okay?
I can.
Okay, wonderful. Thank you, Marjorie, and to the League for inviting me to be here. It's great to be with you. And as Marjorie indicated, I'll start off with an overview of the Wisconsin state court system. So that system is established by our state constitution in Article 7, and it provides that our court is constituted of a Supreme Court, Court of Appeals, circuit or trial courts, and municipal courts if they're authorized by the legislature. So I'm going to start with the Supreme Court. It is the highest court in our state. It makes decisions that set precedent for the whole state, and they have a real law developing function. They get to pick the cases that they hear for the most part, the justices on the Supreme Court, and they're supposed to generally, they have a lot of discretion in which cases to take. but they are generally supposed to take cases that focus on real or significant questions of federal or state law, or areas of law that need clarification, or development, or that would have a statewide impact. It's a novel question and has a statewide impact, or a legal question that's likely to recur unless they resolve it. And of course, the Wisconsin Supreme Court is the final authority on the interpretation of the Wisconsin Constitution. This court also has some administrative functions. It supervises the Wisconsin court system overall, and it's also responsible for judicial and attorney and lawyer conduct. Turning to the membership, the Wisconsin Supreme Court has 7 members. Each is elected in a statewide election, and the governor can appoint a member if there's a vacancy midterm. Each justice serves a 10-year term and can be reelected. As we heard earlier, the election occurs in the nonpartisan spring election in April, with a February primary if there are more than 2 candidates for an opening. Because there are 7 justices and then they have served 10-year terms, not every April election will have a Wisconsin Supreme Court justice on the ticket. The Constitution also provides that only 1 justice can be up for election at any given time. The Chief Justice is selected by a majority of other justices on the court for a 2-year term. And some of you might remember that's a relatively recent development, because up until 2015, the chief was the longest serving justice on the court. And at that time, that was then Chief Justice Shirley Abrahamson, who had served in that position since 1996. But when that change occurred in 2015 through a constitutional amendment, then Chief Justice Rogensack became the Chief Justice. Currently, our Chief Justice is Annette Ziegler. As for cases, as I mentioned earlier, the justices get to select the cases that the court hears. Only 3 justices are needed to pick a case. I think the last statistic I heard is that the court hears only about 5 or 10% of the cases for which it receives, a request to hear a case. And it usually hears those appeals that are sent to them from the lower courts, although less frequently it might take a case on what's called a petition for original action, where it gets to hear the case in the first instance. One interesting side note on the original actions is that the court doesn't have the benefit of a full trial record that might be developed by a circuit court or lower court opinions. And so that's one of the reasons it's a relatively rare phenomenon, or it's supposed to be relatively rare for the court to hear original action petitions. But I would say it's become more common in recent years. There's almost always an oral argument in each case, and the public can go to the state capitol where the court sits and watch, or it can also watch those arguments online on Wisconsin Eye. And in addition to these kind of meaty cases about Wisconsin law, the court also issues all of the decisions that the state issues on attorney discipline. Just one last note on the Supreme Court. The court hears arguments from September through May, generally at the latest, and they issue all of their decisions by about early or mid-July. It issues about 50 decisions a year, not considering the attorney discipline cases. There are majority, concurring, and dissenting opinions frequently. You need a quorum of 4 justices to make law on a particular issue, though. So if you have a decision that doesn't have at least 4, it's not going to make law, but it might be persuasive for other reasons. One notch below the Supreme Court is the Court of Appeals. That court was not created actually until the late 1970s. And before that, it was only the trial court and the Supreme Court. The Court of Appeals is what's called an error correcting court that's supposed to correct errors committed by circuit courts. It doesn't have discretion to reject cases. It's got to hear everything that comes to it. And so the court is a real workhorse. It does have a limited policy-making role. Their decisions can set precedent, but only to the extent that the court decides to formally publish an opinion, which is not that often. The Court of Appeals is divided into 4 districts. There are 16 judges on the court that are spread across those 4 districts. These judges are also elected. They have 6-year terms. So, for example, for those of us in Dane County in southern Wisconsin, Rock County, even I think as far up as Waupaca County, we're in the District 4 Court of Appeals. And this year, due to a retirement, there's an opening in that. I think one person is running for that position, who is a Dane County Circuit Court judge. So you might see that race on the ballot this year, in addition to the Wisconsin Supreme Court case. Second to last, circuit courts. They're the trial courts that have general jurisdiction to hear any civil or criminal matter. They're the only, of the courts that I've talked about so far, they're the only ones that have trials or take evidence. The judges on the circuit courts are also elected. They serve 6-year terms. Like the other judges, if they're elected in April, they take their seats in August generally. And the governor can appoint judges when there's a vacancy. For those who are interested in the court system, many judges, after COVID have started streaming proceedings. So I think you can go to each court's website and figure out how to do that if you're interested. And then finally, municipal courts are courts that are authorized by the legislature, but are typically run entirely by the municipality in which they're located. And they will hear violations of their ordinances and civil matters, like first offense, driving or operating while intoxicated, which is not a criminal matter in Wisconsin. Municipal judges are elected. They have 2 to 4-year terms. And interestingly, unless their municipality requires it, you don't have to have a law degree to be a municipal judge. And as far as the courts that are mentioned in the Constitution go, I've been through all of them. You might hear about judges and courts in other contexts that are not covered by the Wisconsin Constitution. For example, administrative law judges hear a lot of things in the state, but they're in the executive branch and they hear cases that don't necessarily need to be escalated to circuit court. So that would include unemployment compensation appeals, corrections issues like parole revocations, licensing matters, and appeals on anything, pretty much everything that the executive branch touches. So one benefit is that administrative law judges are often subject matter experts on what can be really technical issues. And they do hold trial type hearings and take evidence frequently under rules that are a little bit less restrictive than in circuit court. Of course, Wisconsin has tribal courts too, to hear disputes under tribal law. But that is your brief run through the Wisconsin court system. And I will hand it off to Rob for some discussion on recent decisions.
Well, thank you so much for having me. It's great to be with you all virtually this evening. If we're thinking about why it is that the Wisconsin Supreme Court race matters, it helps to reflect on some of the work that the Wisconsin Supreme Court has been doing lately. So I think our plan is that I'll start off talking about a couple of important recent election-related cases, and then Krista will talk about a couple more cases, and then I'll end with a discussion of one final case. And I will just jump right in with one of the biggest cases in recent memory that the Wisconsin Supreme Court decided last year, and that's Johnson versus Wisconsin Elections Commission, the case involving redistricting, where the court adopted new electoral maps for the state. To step back, some of this story will be familiar to many of you. In 2011, Republicans had unified control of state government, and they produced electoral district maps with an eye toward locking in their electoral advantage. And by most standard measures used to judge gerrymandering, what they produced were among the most politically skewed maps anywhere in the country. Even in years when Democratic candidates were winning statewide races in Wisconsin, even in years when Democratic legislative candidates were winning more votes statewide than their Republican counterparts, Republicans were maintaining firm control of the state legislature throughout the decade. So after the 2020 census, it was time to draw new maps. This time, Wisconsin had divided government. The legislature initially passed new maps that looked a lot like the old maps. They were built on the prior maps. They re-equalized the populations of the districts as they were required to do legally, but the maps were essentially designed to cement the control that the Republicans had. The governor proceeded to veto that map, and so then the question of new maps went to court. Now, that litigation was not necessarily litigation that had to happen in the Wisconsin Supreme Court in the 1980s, the 1990s, the 2000s. After each of those censuses, it was a federal court that adopted maps for the state. And in fact, there were some members of the Wisconsin Supreme Court that had previously expressed reservations about the Wisconsin Supreme Court getting involved and thought that it was preferable for a more politically insulated federal court to do the job. But this time around, a majority of the justices agreed to hear an original action. And so this was not a case that started in the lower courts and worked its way up. It was a case that went straight to the Wisconsin Supreme Court. And litigation over these electoral maps proceeded in two stages. First, the court had a briefing and argument over the criteria that it should use when adopting new maps. And a lot of the action in Johnson versus Wisconsin Election Commission happened at this step. Some of the litigants urged the court to adopt partisan fairness as one of the driving criteria that they would consider when drawing lines. The legislature and its allies argued otherwise and instead said that what the court should do is seek to minimize change from the prior maps, a so-called least change approach. That least change approach was not an approach that had been used by the federal courts when they redistricted the state in previous decades. And those federal courts had stressed the need to adopt maps that didn't have an evident partisan balance. But this time around, the Wisconsin Supreme Court, voting 4-3, said that it would not consider the partisan fairness of the maps and that it would adopt this least change approach. And of course, when you are building upon a map that is politically skewed, of course, that's going to result in a new map that retains that political skew. So having made those important decisions about the criteria that they would use at step one, the court then had the parties submit maps to them that attempted to comply with the criteria that they had announced. And there were some other legal criteria that were necessary to comply with as well, including equalizing the populations of the districts, trying to make sure that the districts were sufficiently compact, respected political subdivisions, and so on. Well, the maps that the legislature submitted were the same ones that it had voted on and passed earlier, ones that reinforced its prior gerrymander. The governor's maps submitted in the litigation blunted the gerrymander to some extent, but they were still quite favorable to Republicans because they had to comply with the Supreme Court's least change directive. Well, after it reviewed the maps that had been submitted, the court voted 4-3 to adopt the governor's maps. And this time it was Justice Brian Hagedorn, who is someone who identifies as a judicial conservative, but is often the court's swing vote. He sided with the court's more liberal justices to vote for the governor's maps, which he said actually did most faithfully comply with the least change directive that the court had provided. Well, that wasn't the end of the matter. The legislature challenged the Wisconsin Supreme Court's decision to adopt the governor's state legislative maps and took that to the United States Supreme Court, arguing that the governor's maps actually violated federal law because of the way that they had drawn districts in the Milwaukee area. The governor had created an additional majority Black district in the Milwaukee area, something that the governor thought was appropriate given the change in population demographics in the Milwaukee area. But the U.S. Supreme Court took on the case and said that actually the governor and the Wisconsin Supreme Court hadn't shown that there was a sufficient reason for considering race during the line drawing process in the way that the governor had. And so they sent the case back to the Wisconsin Supreme Court. Now, at that point, the Wisconsin Supreme Court could have just tweaked the lines in the Milwaukee area, but instead it jettisoned the governor's maps entirely and voted for the legislature's state legislative maps instead. Really a fairly striking result that the legislature at the end of the day got the very maps that had been rejected by the political process, the maps that the governor had vetoed. So that is, and those maps, by the numbers, are ones that, in terms of judicially created maps, are far and away the most politically skewed maps that a court anywhere in the country has created in at least 20 or more years. The partisan asymmetry levels in those maps are 3 to 5 times higher than the average court-adopted map. For the most part, courts take quite a bit of care to ensure that maps are even-handed in a partisan way. And so a lot of controversy over the result in that case. Okay, so that's the first case, Johnson versus WEC. The second case is a case that goes directly to voting, a case that the Wisconsin Supreme Court decided last year called Tagan versus Wisconsin Elections Commission. In this case, there were 2 voters that challenged the legality of guidance that the Wisconsin Elections Commission had issued in 2020 in an effort to help facilitate voting during the pandemic. The WEC had authorized municipal clerks to collect absentee ballots in drop boxes, and also said that voters could have family members or others return ballots on their behalf. And by spring of 2021, there were 500 plus drop boxes that were being used around the state. The litigants in this case, however, argued that the relevant state statutes authorized neither drop boxes nor third-party ballot returns. And in another 4-3 opinion, the Wisconsin Supreme Court agreed with those challengers. The statutory language in question refers to absentee ballots being, quote, mailed by the elector or delivered in person to the municipal clerk. And the majority said that depositing a ballot in a drop box doesn't count as an in-person submission to the clerk. And the court also said that because the statute refers to delivered in person, that means that voters have to personally deliver their own ballots and not the ballots of others. The dissent had a different view, suggesting that there was nothing in the statute that precluded clerks from choosing to use drop boxes as a way to receive ballots, and also nothing that required in-person delivery to be made by the elector. Now, in the wake of this case, there was concern in particular about what this ruling might mean for voters who are physically unable to return their own ballots without assistance. And litigants actually went to federal court to say that as a matter of federal law, such voters have a right to be accommodated. And a federal court agreed with that. And so there was some subsequent guidance that the Wisconsin Elections Commission had to give that at least those qualifying individuals were still able to get that accommodation. Okay, so I think I'll leave things there for now and turn it back over to Krista.
Thanks. So I'm going to shift away from election cases for a minute and go to State ex-rel Call versus Prane. And this is an interesting case. And sorry, there's the snowplow going by. That's creating a rumble in the background. But when I explain it to my lawyer and non-lawyer friends, they say, how can this even be? Because the holding of this case is that even when, if you're serving on a state board and even if your term is expired, you don't necessarily need to leave. So this case started in 2021 when the term of Fred Prane to serve on the State Natural Resources Board expired. And the board is a policy-making body for the Wisconsin Department of Natural Resources. It's got 7 members who serve staggered 6-year terms. They're all appointed by the governor with the confirmation by the Senate. It approves all of the rules the DNR enacts, which have the force of law, and it considers a number of other really important issues as well, related to public lands, related to hunting, you name it. The wolf hunt, for example, was a really controversial issue at the time. So Mr. Prane's term expired on May 1st of 2021. And at that time, the board had a 4-3 Republican majority. So if he left, it would shift the balance of power on the board to a majority Democrat appointee board. Even though, like the spring elections, the natural resource management in Wisconsin is supposed to be apolitical. That's kind of our history here. But in more recent years, the partisan nature of the board has become a little bit more apparent. So the Governor Evers appointed someone, Sandy Nass, to replace Mr. Prane, and she is a natural resource expert from the Ashland, Wisconsin area. But Mr. Prane wouldn't vacate his seat, and he said he wouldn't until the Senate confirmed his replacement. And then the Senate, for its part, wouldn't schedule a hearing, much less a vote on that replacement. So he was just getting to sit there indefinitely. So where did Prang get this idea that this was an okay thing to do? Well, there was a 1964 case that suggested it was legal called Thompson versus Gibson. And that said that for some government boards where a statute doesn't explicitly say the end of your term creates a vacancy, that member can hold over until the governor nominates a replacement and the Senate confirms that person. There isn't a lot of precedent of people actually doing this, but it has happened 2 times before in the Natural Resource Board's history. Twice when a member whose term expired wouldn't make way for their replacement. Coincidentally, every time that somebody has held over, it's been a male occupant of that seat and the replacement was female. And I only mention that because the natural resource management has historically been somewhat male dominated. So this has been it's kind of a notable point, I guess. But most people just step down when their term is done, regardless of their replacement, if their replacement has been confirmed. So Mr. Prang got a lot of criticism for staying over in his seat. He said that those who wanted him out were motivated by politics. There were some records that were released that showed that he consulted with multiple Republicans about whether he should hold over and keep the Republican and majority appointee on the board. So take that for what you will. But the question is, how does this get to the courts? Well, Attorney General Josh Call filed what's called a quo warranto action, which is a special type of legal action to declare whether somebody is improperly holding office. The circuit court found that Mr. Prang's holding over was lawful and dismissed the case. And then the case skipped the Court of Appeals and went right to the Supreme Court, which ruled last summer 4-3 that Mr. Prang's holding over was lawful. There were 2 essential bases for the court's opinion. First, they held that the expiration of Mr. Prang's term didn't create a vacancy, that the legislature gets to decide when there's a vacancy, and the statute about vacancies doesn't mention a term expiration. It mentions things like when the somebody dies or resigns or is removed, but not when the term ends. And if somebody is appointed, they can't bump the prior occupant until that person has been confirmed and quote unquote properly appointed. Second, there's a second question in the case that, well, couldn't the governor just remove Prang? And the court held that the governor could only remove him for cause, which is inefficiency, neglect of duty, official misconduct, or malfeasance in office. In other words, he doesn't just serve at the pleasure of the governor. The governor has to come up with some sort of cause before he can remove him. The Attorney General, which brought the case, made a separation of powers argument here and said that, well, you know, if the executive can't manage appointments as he wants to, that impinges on the executive authority. And the court said, well, that's not really a fully developed argument, but it went into some history to find that the governor had limited approval or limited removal authority over administrative appointments since really the beginning of the state. So the 3 dissenting justices said basically, well, they called it majorities holding absurd, because they said it allows Prang's 6-year term on the Board of Natural Resources, which expired over a year ago, to last for as long as Prang wants it to, so long as he refuses to leave and the Senate doesn't confirm a successor nominated by the governor. And even though his term is long expired, the government can't remove him except for cause. And that, the dissent said, steers our state's government directly into disorder and chaos, threatening the fragile separation of powers central to its functions. So the thrust of the dissent's opinion was basically, there's another statute here at play we got to look at, and that's the one that sets the term at 6 years. That's a limit too. The dissent found that that does create a vacancy, and that if you've got staggered 6-year terms, that really doesn't have much meaning if people can hold over. The court also said that, the dissent also said that Mr. Prang could be removed without cause. They said, while he was validly serving in his 6-year term, they agreed that he could only be removed for cause, but when his term expired, he could be removed at the governor's pleasure. So there are some, a couple of democracy implicating issues with that case, those mostly being whether one person or the legislature even getting to decide the membership of this executive board. And the legislature can do that essentially not by taking a confirmation vote, but just doing nothing, not even scheduling something. So if they plus that person who's holding over are working together essentially in that way, they can stymie the governor. And there are hundreds of positions like that in state government. So if this practice were to expand, it could have really profound effects. And it already has had effects on the Natural Resources Board, which took some really important votes on things like PFAS rules and other matters while Mr. Prane held over. I'll give you sort of the rest of the story too. After Governor Evers won re-election in November, Mr. Prane finally stepped down in December. So about a year and a half after his term expired, Governor Evers' appointee, Ms. Nass, has taken her seat. The Senate hasn't confirmed her yet or set a hearing date, but she can serve provisionally until then. And then, of course, if she's confirmed, she can serve afterwards. And I understand that other holdovers and other offices like the Technical College Board have also stepped down. I'll make one other note that's kind of relevant to some of the cases that Rob has mentioned, and this one. The Wisconsin legislature intervened in this case as a party at the Wisconsin Supreme Court. And as a party, the legislature could file briefs and present oral argument, which it did. Nope. Are you guys getting a flashing screen?
Everything looks good from here.
Okay. Let me grab I don't think it's on my end. Okay. So it's not very well understood that as part of the 2018 lame duck legislative session, the Wisconsin legislature gave itself more powers to litigate and intervene in lawsuits. They also gave themselves the ability to hire private legal counsel and not use the Wisconsin Department of Justice. So they intervened here to argue that Frederick Prane should be able to hold over in his office. And you could, reasonably ask why the legislature would do that, because if they didn't like the nominee, they could just hold a confirmation hearing and reject her. Or, for that matter, they could change the law about appointments. So they had other options than intervening in this case, which was already being litigated by other parties. And all of those other parties were already represented at taxpayer expense. So I just wanted to note that that's part of a more recent trend, I think, since 2018, where the legislature litigates and doesn't legislate on some of these issues. And I think it's relevant to this forum because if there are more issues resolved in the courts rather than through the legislative process, that magnifies the importance of the Wisconsin Supreme Court and the court system overall. So that's the Call versus Prane case. And then I'm going to move on next to one more case involving the executive branch called Wisconsin Legislature versus Palm. And that was decided in the early days of the pandemic of May of 2020, after the State Department of Health Services Secretary Andrea Palm had issued a number of public health orders that did, as we all remember, he shut down businesses, schools, travel restrictions, limited gatherings, and a number of people didn't like that, and they claimed that it was overreach, and that includes the Wisconsin legislature, which filed the case challenging the Department of Health Services Secretary's authority to issue these orders. And it did so directly in the Wisconsin Supreme Court as an original action. It didn't go through the lower courts first. So already there you have two kind of extraordinary things: this original action filed by the Wisconsin legislature, and it was also on an extremely compressed timeline. So the case concerned Public Health Order 28, which was the Safer at Home order, which Secretary Palm issued on April 16th of 2020. That prohibited travel, public and private gatherings, it closed schools, it closed businesses, and it imposed a 6-foot social distancing requirement. But it was only temporary through the end of May of 2020. So the issue in that case, as raised by the legislature, was whether Order 28 was actually a rule. And a rule might not sound different from an order, but they're quite different as far as the law is concerned. And one difference is that a rule needs to go through the formal rulemaking process, which in Wisconsin can take years, and While emergency rulemaking power also exists, it has its own limits. And then at the end of the process, the Wisconsin legislature has veto power over rules. So the Wisconsin Supreme Court held on a 4-3 vote that Order 28 was in fact a rule. And the majority were Justices Rogan Stagg-Ziegler, Rebecca Bradley, and Daniel Kelly. And dissenting were Justices Ann Walsh Bradley, Rebecca Dallett, and Brian Hagedorn, who Rob mentioned earlier is kind of the swing voter. The majority found the order had certain trademarks of a rule, like it was broad in applicability, it had the effect of law, it was issued by an agency, and so forth. And they also really didn't like one aspect of the rule, which is that it had criminal penalties. So they struck down Order 28, which is something even the Wisconsin legislature hadn't asked for. They wanted the order to remain in place for 6 days while the department promulgated an emergency rule. There were 3 dissenters who all filed their own opinions, but they all agreed that Order 28 was not a rule, and then it wouldn't make any sense for Order 28 to be a rule. And that public health authority, since the beginning of the 1900s in Wisconsin, has always been broad, even before that. And that's by necessity, because when you've got to have public health officials have to have the ability to act quickly and decisively when there is a public health threat. And this order was consistent with that. And Justice Hagedorn in his dissent said, the statutes, they're broad. And while the legislature might not like that, and he called that buyer's remorse for how broad they had made the secretary's authority, the answer was to change the law. So the upshot was that the state lost its centralized authority to manage the COVID-19 crisis and impose travel restrictions and things that cross county lines, or make it orders that affected people statewide. One exception to that was about the ability to close schools. But it didn't impact the power of local public health officers. And that came up in the case that I believe Rob is going to discuss next.
So the last case that we wanted to discuss is another pandemic-related case, and that case is called Becker versus Dane County. And this case is actually, I think, as notable for what it didn't decide as what it did. So this case, again, involves the governmental response to the pandemic, but at the local rather than state level. And the plaintiffs in this case questioned the validity of orders that had been issued by the director of public health Madison in Dane County. And these were orders mandating face masks and restricting gatherings, among other things. And there are state statutes that confer authority on local public health officials to, quote, promptly take all measures necessary to prevent, suppress, or control communicable diseases, and, quote, do what is reasonable and necessary for the prevention and suppression of disease. Well, the plaintiffs argue that this language didn't actually allow the director to issue and enforce the disputed orders, and that if it did, and the language is fairly broad, then in their view, the law amounted to an unconstitutional delegation of legislative authority to local public health officers. That latter argument was part of an effort. It was an effort on the part of the plaintiffs to invigorate what's known as the non-delegation doctrine. According to that doctrine, there are limits on how much power legislatures can delegate to other actors, such as executive branch agencies or local officials. And historically, it's been rare for courts to find excessive delegations. Both state courts and federal courts typically have given legislators significant leeway in delegating their authority, recognizing that is an inevitability, really, when it comes to the functioning of modern government. Well, by a 4-3 vote in the Becker case, in another one of these 4-3 opinions, the court actually disagreed with the plaintiffs, upheld the orders. So this is another one of those cases where you have Justice Hagedorn casting the swing vote with the more liberal justices. And he said that the director did have the authority under the statute to issue and enforce the orders, and the majority rejected the non-delegation argument. But Justice Hagedorn wrote a separate concurrence in which he indicated that although he didn't think that the plaintiffs in this case had adequately made out their case for strengthening the non-delegation doctrine, he said that he remained open to, quote, more broadly reconsidering our approach to the non-delegation doctrine in future cases. So, signaling to future litigants that this might well be something that the court, at least as currently comprised, would be interested in dealing with. And as a practical matter, the more robustly the non-delegation doctrine is enforced, the more likely you are to have government agencies hamstrung in various ways and to have executive officials and others encounter difficulties acting on matters like public health, workplace safety, air and water quality, and much more. The idea being that the legislature just isn't allowed to confer broad authority to those officials to deal with those sorts of problems. Okay, well, I think that case, is useful because it provides a little bit of a bridge from what the court has already decided to what it might decide in the future. So we wanted to end our presentation by looking forward and talking a little bit more about what we might expect. As I think, many of you are already aware, this election is coming at a fairly unique moment, a moment when the court is poised to confront a range of hot button issues, including gerrymandering and abortion rights. And we'll say a little bit more about both of those issues. But the list goes well beyond that. And partly that's a function of the fact that the state now has divided government. So there are many questions that might otherwise have gotten resolved by the other branches of government, but instead, because of gridlock, deadlock, those questions are increasingly finding their way into court. And as I think, we've indicated already, this is a case that could tip the court's ideological balance. For the past 15 years, the court has had a conservative majority. And so essentially the question in this election will be, does that majority continue, or will the court become a at least somewhat more liberal court after the election? Now, the Wisconsin Supreme Court election is achieving some unique levels of prominence, in part because it's one of the very few state Supreme Court elections in 2023. The only other one is an election that'll happen later this year in Pennsylvania. And so it's become a bit of a national focal point. But what we're seeing in Wisconsin is not really unique. I mean, state courts across the country have taken on newfound prominence in recent years. There's been a growing recognition of the importance of what state courts do. Some of that has followed in the wake of the U.S. Supreme Court's decision to pull back from being involved when it comes to issues like gerrymandering and reproductive rights. And so it's leaving more that falls to the state Supreme Courts to potentially do. And I think there's been some recognition that state Supreme Courts might even play a role in deciding cases involving contested elections, including possibly presidential elections. And so folks who worry about a state Supreme Court being asked to weigh in on, say, the validity of votes in a closely contested election are very interested in the composition of those courts. Now, unsurprisingly, given the stakes, these elections have become more contentious in recent years. And we are likely to see an unprecedented amount of spending in this Wisconsin Supreme Court race. Now, I will just say briefly, Marjorie asked me to address whether this growing prominence of state Supreme Courts could be counteracted in some way by a case that's currently pending before the U.S. Supreme Court, and that is a case called Moore versus Harper, involving the so-called independent state legislature theory. This is a case where the Supreme Court is reviewing a decision from the North Carolina Supreme Court to rein in partisan gerrymandering in that state. And the legislature went to the U.S. Supreme Court to say that under the U.S. Constitution, it's up to the state legislature and not other state actors to adopt election regulations, including drawing district lines for congressional districts. And so if the U.S. Supreme Court were to side with the North Carolina legislature in that case, it could, at least to some extent, limit the ability of state courts to become involved in disputes involving federal elections. So that might mean in Wisconsin, for example, that the Wisconsin Supreme Court could be limited in the extent to which it could decide to take on gerrymandering of the state's congressional districts. But the theory that's being presented in Moore versus Harper is not a theory that would apply to state electoral rules or to state legislative districting. The power of the Wisconsin Supreme Court or other Supreme Courts to regulate their own state elections, to enforce their own state constitutions in the state electoral context would remain the same. I will add, by the way, that there is some uncertainty about the future of that Moore versus Harper case. The North Carolina Supreme Court changed hands in November 2022. That is a court that actually has partisan elections, and it went from having a Democratic majority to a Republican majority. And the new Republican majority on that court voted to rehear the court's decision accepting that gerrymandering is prohibited by the state's constitution. And so it's possible that the newly comprised state Supreme Court in North Carolina actually could moot the Moore versus Harper litigation. And so we'll have to just wait to see what happens in the months to come on that. So that leads me to talking a little bit more about the redistricting situation in Wisconsin. What paths might be available for a newly constituted Wisconsin Supreme Court to take a fresh look at our electoral districts in the coming years before the next census, which won't be until 2030. And the answer to that question is that there are some legal paths available for litigants who would be interested in seeking further review. And it seems highly likely that if the composition of the Wisconsin Supreme Court changes, there will be litigants who ask the court to consider whether the current districts are an unconstitutional gerrymander. So first of all, let's think about what the Wisconsin Supreme Court decided already. That case that I already spoke about, Johnson versus Wisconsin Elections Commission, that was a case involving the validity or invalidity of the old maps, the ones that were adopted in 2011. So there actually has not yet been a case where the Wisconsin Supreme Court has been asked to address the validity of the new maps. Now, you might say, well, didn't they in effect rule on their validity since they themselves adopted the new maps? But in that case, Johnson, they really were tasked with just resolving one legal claim, which was a claim about the unequal populations of the old districts. And so they weren't formally presented with a claim of partisan gerrymandering or other types of legal claims. And so at least as a formal legal matter, it should remain open to litigants to go back to the Wisconsin Supreme Court and to say, we realized that before you didn't want to consider this question of partisan fairness, and you actually included some language in Johnson saying that there is no right to partisan fairness in the Wisconsin Constitution. But that was essentially just dicta, not necessary, language that is not necessary to decide the case. And again, it is possible that if the membership of the Wisconsin Supreme Court changes, there would be some receptivity to those kinds of arguments. There will be questions about how quickly this might play out. Would it be possible that Wisconsin actually could have new districts in place for 2024? The answer is that that future litigation would have to proceed fairly quickly, but there is a chance that if the Wisconsin Supreme Court were to take up a case in mid to late 2023, that it could conceivably adopt new district lines for the 2024 election. I will leave things there and I'll turn it back over to Krista to say a little bit more about the issue of reproductive rights.
Thanks. So as Rob said, abortion could be something that comes to the Wisconsin Supreme Court or the courts in the coming years. So I'll just kind of give you a rundown of where we are. As we all know, the U.S. Supreme Court in the Dobbs case last summer found no constitutional right to an abortion, overruling Roe versus Wade, and it returned this issue, as it said, to the states. So now all eyes are on the states and what each state's law allows as far as abortion and reproductive services. And states have handled it differently. Kansas voters rejected a constitutional amendment last summer that would have outlawed abortion. Other states have gone to the legislative process, like Minnesota, which just a week or so ago passed a new law strengthening the right to an abortion, although that had already been protected by the state constitution. But in many places, the issue is going to the state courts directly and what's in the existing laws. And will they find the right to an abortion in statute or in state constitutions? In Idaho, the answer was no, there's no right to an abortion. South Carolina found that there was. So this issue is currently in the Wisconsin Circuit Courts, not yet the Wisconsin Supreme Court, but it is in Circuit Court. So after Dobbs, Wisconsin did not have what some people call a trigger law, which would go into effect as long as Roe versus Wade was vacated. But it does have a law on the books from 1849 that creates criminal penalties, not for women seeking an abortion or performing an abortion, but for those who assist women who get that service. And it also does not have any laws restricting travel for the purposes of obtaining an abortion. And the state hasn't enacted any laws post-Dobbs. But what it does have is this one case, Call versus Ermansky, which is currently in Dane County Circuit Court. It's a declaratory judgment action seeking to asking the court to find that the old 1849 ban is not enforceable. And I think the primary basis for that is that there have been other laws that have been passed since 1849 that regulate abortion, and it's sort of fundamentally inconsistent to have a ban on the books at the same time that you have other laws that regulate that same service. So the current court litigation is all about the old statutory law brought by the Attorney General. There have been a number of interveners. It's not Attorney General Call did not raise constitutional arguments. As I understand it, some of the interveners have alleged a due process claim that the law is void for vagueness. The Attorney General in Wisconsin cannot challenge the constitutionality of statutes. That's precedent that we have here. So that may be one reason why the case is focused on what do the statutes currently say and what do they allow. So that's where we are in Wisconsin. But in the meantime, many physicians, I think most physicians are not performing abortion services due to the lack of clarity from the old 1849 ban.
Well, let's switch now to some questions and answers. And Rob, if you could talk for a minute about judicial philosophies and versus partisanship.
Well, I could say something about it, and then maybe Krista would weigh in as well. I mean, Wisconsin state judicial elections are formally speaking nonpartisan elections, and so the candidates are not listed on the ballot as Democrats or Republicans, although parties often are involved in some way, providing endorsements or funds to one candidate or another. Judicial philosophies have some intersection with partisanship, but they are somewhat discrete. Judicial philosophies sometimes refer to the methodologies that justices try to use when they're deciding cases. So, we often think of originalism as more associated with a conservative judicial philosophy. The justices who tend to identify as judicial conservatives, and so that's two of the four candidates who are going to be on the ballot in this election. They're essentially indicating that they are folks who align in their judicial outlook with the majority on the U.S. Supreme Court, with the current majority on the Wisconsin Supreme Court in the way that they approach the Constitution. That may have some intersections with partisan politics, although the overlap is not going to be 100%. There will be at least some instances in which even the most conservative or liberal justice is not reflexively going to side with the desires of the Democrats or the Republicans.
Krista, did you have anything you wanted to add to that?
I can add just a few things. I've seen some of the candidates in this election be described as, say, quote unquote, a constitutional conservative. I'm not really sure what that means myself. I don't know if they've really described that in any sort of public way. If they have, I've missed it. But I think one of the buzzwords that we hear a lot as practitioners in Wisconsin today is originalism and textualism, and the focus on the text, which is associated with a more conservative view. but that's not necessarily how it always works in practice. And, textualism being, devoted to the text of what does the statute really say can cut both ways. And so I think that's one reason that Justice Hagedorn, for example, who's considered a swing justice, does sometimes vote with those who are considered liberals on the court, because he's applying this philosophy sort of regardless of the outcome in many cases. Whereas liberals have accused some of the conservatives on the court, such as in the Palm case, of judicial activism. So sometimes those labels are useful, sometimes they're not, but officially this is a non-ideological election. So sometimes those buzzwords help, but it's kind of a mix, I guess.
And Krista, could you help the audience figure out how to choose a candidate?
I can provide some suggestions. So, one easy thing to do is to watch them in action. There are numerous places where you can see them interviewed. There was a candidates forum in January that was sponsored by WisPolitics, and you can watch that forum still on the WisPolitics website, wispolitics.com, and kind of see for yourself how they answer questions and how they behave. Wisconsin Public Television has done a series of interviews with several of the candidates. And, you can use those strategies to kind of get a better sense of their credentials, their temperament. Do they act like a judge? Some judges tweet, some candidates tweet. So you can always look at the words of that they post themselves. All have judicial records. You can find them. The candidate Dan Kelly, he was a Wisconsin Supreme Court justice after he was appointed to fill a vacancy before eventually losing the seat to now Justice Jill Karofsky. So he signed a number of opinions. He wrote a dissenting opinion, a concurring opinion in the Palm case, supporting, in that matter, the finding the order that the State Department of Health Services secretary had enacted was unlawful. If ideology is important to you, just current candidates Dan Kelly and Jennifer Duro are often referred to as sort of the conservative or Republican supported candidates. And Janet Prohastowitz and Everett Mitchell are referred to as the more liberal or Democratic leaning candidates. So there's a number of public statements they've also made in news articles. There's Ballotopedia, which is a good resource. There's a lot of resources out there you can ask around, but you will have to choose one out of the four in the February 21st primary, and then of the two that are left, select from one of them in April.
Do either of you know if there is data showing that drop boxes do or don't make a difference in election turnout?
I'm not aware of any, good empirical evidence out there one way or another. Drop boxes became much more widespread in 2020, and so we don't have a long history that we can look to for that. And it's difficult to study that kind of thing because elections differ from each other in so many different ways that it's hard to just control for that one variable. And so not that I'm aware of.
Krista, you were talking about the Supreme Court taking original action, and there's a question from the audience whether there are requirements for the state Supreme Court to take original action instead of letting the cases work through the circuit court and Court of Appeals.
There are not requirements as such. There are guidelines that have been developed over time in Wisconsin case law. And, it's there are supposed to be, limits on when original actions are taken, just, in like exigent circumstances or situations that need immediate resolution by the Wisconsin Supreme Court, and no other court can do it, and no factual development is needed. But, the court is ultimately the one that gets to decide if it wants to take a case or not, or if those criteria are satisfied or not, or if they're even going to look at those criteria. So it's a bit of a self-enforcing rule that the court can utilize or not.
Rob, a couple of questions about gerrymandering. You talk about gerrymandering being a measurable, factual thing. Does this mean that a judicial candidate's statements about gerrymandering aren't political statements?
I mean, I think that there are, factual statements that you could make about the maps, there, and so, I don't know exactly what the statements are, but, yes, I think that you could just descriptively say some things about the nature of a particular map. Look, there are measures of partisan bias or the efficiency gap. I mean, those are two of the more prominent ones. You can look at the results that maps have produced in the course of elections, and you can say factual things about that. I mean, we know, for example, that in the 2022 election, we had Governor Evers winning the statewide gubernatorial race for the Democrats, but at the same time, these state legislative maps produced near super majorities for the Republicans, and so those are just descriptive things that you can observe about the maps.
Would a candidate who has spoken about gerrymandering have to recuse him or herself if elected if the court hears gerrymandering cases in the future? If he or she does not recuse herself, could any decision be appealed to the U.S. Supreme Court on the basis of this failure to recuse?
So, it is possible or even likely that there would be requests for such a person to recuse. I think that as the law currently stands, it's unlikely that recusal would be required. I mean, if we think about what is allowed or disallowed for judicial candidates to say during a campaign, what is forbidden under the ethics rules are that candidates may not make pledges, promises, or commitments with respect to specific cases or issues that might come before them. But candidates are not barred from sharing their values or their opinions. And the U.S. Supreme Court actually has made clear that candidates have a First Amendment right to announce their views on disputed legal or political issues. And so, consistent with that, as long as a candidate isn't making promises, right? If a candidate does that, then yes, we're likely to be in recusal territory. But if a candidate is just speaking more generally about their views, then less likely. Now, part of that question was, okay, suppose there is a motion for recusal, that motion is denied, the justice sits and decides the case. Could there be a request for further review? I mean, the answer to that is there probably could be a request. An argument could be made that somehow violates federal due process rights. The U.S. Supreme Court in the past has set quite a high bar for finding a violation there. And so, I would say it's not the likeliest claim to prevail, but, this sort of litigation could get quite contentious.
Another question about the Johnson case. How did the Supreme Court justify that it violated the Voting Rights Act to add a majority Black district, but it didn't violate the Voting Rights Act to subtract a majority Black district?
Yeah, this gets a little bit complicated legally. The question is about in what circumstances are map makers allowed to consider race when they're drawing lines. The U.S. Supreme Court has said that the Constitution's Equal Protection Clause presumptively makes it improper to consider race when line drawing. And so if you are going to consider race, you have to have a good reason to do it, including your desire to comply with the Voting Rights Act, which is a federal statute that tries to protect representation for minority groups. And what the U.S. Supreme Court said is that essentially neither Governor Evers nor the Wisconsin Supreme Court established a sufficient record that providing sufficient representation for the African-American community in Milwaukee required the creation of a new majority-minority district. It was essentially, they hadn't adequately shown their work. And so then, the flip side of that question, well, why wouldn't it be a violation of the Voting Rights Act for a Black majority district to have been taken away? Well, the question that was resolved by the U.S. Supreme Court was really, again, mostly about whether it's proper or improper to consider race when drawing the lines. And the Republicans in the legislature who created their map said that they did it in a race-blind way. And the result of that process was that there was one fewer majority Black districts, but that wasn't a deliberate, something that they did deliberately. There could be follow-on litigation where someone tries to establish a record saying that actually it is appropriate to add one or even two more Black majority districts in Milwaukee because the African American community is otherwise not getting an adequate level of representation. The reality is that those kind of claims have not been faring very well recently in federal court. The U.S. Supreme Court has become increasingly skeptical of them, but that's sort of why we landed where we did on those questions.
Krista, back to the Crane case. Can you explain how failure to vacate your role isn't malfeasance in itself and therefore a cause for which a board member could be removed?
Because the Supreme Court found that the failure to vacate wasn't unlawful, based on that Thompson case from 1964 and some other things that, it can't be malfeasance if it's not illegal, I suppose. But it's a fair question. The dissenting opinion said, started out with a scenario like, imagine you're in any job, and you won't leave. What would happen? And so it doesn't really make sense. It doesn't really make intuitive sense that this would be all right, but because for any other situation it wouldn't be. But here it found that was not only lawful, and then nobody ever reached the issue about whether it was malfeasance.
There's some statistics that in 2021 and 22, the courts, liberals voted together 88% of the time, and the conservatives 92% of the time. There's also some statistics that during this last court session in 21-22, 54% of the cases were 4-3. Rob, what does some of these statistics tell you?
Well, I think it helps, show pretty vividly that we really have this very starkly divided 4-3 court. I think that percentage of cases in the past year that turned out 4-3, more than 50% of cases, that's the highest that Wisconsin has had in the at least 75 years that people have tried to compile that data. And it's much higher than the national average of those kinds of 4-3 opinions. So, it shows that the justices really are sorted into these ideological blocks. The Wisconsin Supreme Court takes cases that are really the close, difficult cases that really might go either way. And so I suppose that when you have justices that are approaching those cases through the lens of different judicial philosophies or ideologies, it's unsurprising that they're pretty frequently reaching different results.
Krista, when you were talking about the levels of courts in Wisconsin, could you explain what's the advantage for people in having this variety of courts?
Well, I suppose one advantage of it is efficiency and ensuring that only the most important cases get up to the Wisconsin Supreme Court. I think the creation of the Court of Appeals in the late 1970s enabled that and prevented the Supreme Court from having to take more day-to-day kinds of appeals. And then going back down to the circuit court level, the circuit courts there's a circuit court in every single Wisconsin county, and there's some benefit to having some decisions being made in the area in which those issues bubble up. I think more recently we're hearing a lot about staffing challenges, especially in other aspects of the justice system, like district attorneys' offices and public defenders. It's sort of a tradition that wherever a case arises, that's where it's heard, and then it kind of goes up from there to the different levels of appeal.
Rob, could you talk a little about the difference between the U.S. Supreme Court and the state Supreme Court, the type of cases they handle, the election versus appointment?
Right. Well, I mean, first, that's, an obvious difference how the justices get there. The U.S. Supreme Court and all of the federal courts are courts that are appointed by the president and confirmed by the Senate. Wisconsin is in the majority of states in that it elects its judges and justices. Different states do it in somewhat different ways. Wisconsin's approach to do nonpartisan elections is a fairly common one, but there are a number of states, including North Carolina, Pennsylvania, Ohio, where these are partisan elections. And so there's no pretense of nonpartisanship. The candidates run as Democrats or Republicans. There are some states that have appointments. There are some states that have a process where there's initially an appointment, but then there's a retention election. So the judges do have to run, but not until they've been in the job for a while. In terms of the kind of work that the U.S. Supreme Court does versus the Wisconsin Supreme Court, the Wisconsin Supreme Court really does a broader range of work. The U.S. Supreme Court handles federal law issues, federal constitutional questions, federal statutory questions. That's its domain, the domain of federal law. The Wisconsin Supreme Court can hear federal law cases, and frequently it does, especially on the criminal side. It can hear issues about the Fourth Amendment, the Fifth Amendment, the Sixth Amendment. So those cases can be in state court. But in addition to that, the Wisconsin Supreme Court will hear questions that arise under the state constitution. It'll hear questions involving state statutes. And there is common law in the state level too. So there are actually some instances in which state courts, including the Wisconsin Supreme Courts, are to some extent still making law in a way that you don't see in the U.S. Supreme Court. They are helping to develop the law in various areas where there actually is not a lot of statutory framework or constitutional framework for them to work with.
Krista, you were mentioning earlier that of the four candidates, two are liberal and two are conservative. Does that mean in a nonpartisan election, we could have two candidates of one persuasion move forward to the April election?
Yeah, that's a possibility. I have no idea how likely it is. I do know that the two candidates who are often described as conservatives, that's a much more contentious election. Just the way the candidates are, being aligned against each other in some ways. So there could be a lot more attention given to that side of the primary, and more voters come out of the primary supporting those two candidates. It could go the other way. I don't think I've seen any polling, but yeah, it's theoretically possible.
I would just add quickly, I think this is implicit in what Krista was saying, but turnout is hugely important in these elections. These are relatively low turnout elections compared to the general elections in November, and especially the primaries in February. Since 2000, the average turnout for these February primaries has been something like 400,000 voters compared to over 3 million who turn out in the 2020 presidential election, or 2.6 million who turn out in the November 2022 midterm election. The turnout in the primary in 2020 was the highest that it's been, and that was 700,000 voters, but that's still just a 16% turnout. And then the turnout grows somewhat by the time you get to the April election, but in non-presidential primary years, it's often been just around 20% still. And so, if there is more energy, more organization on one side or the other, that ends up making a big difference.
I can tell you that the Madison clerk is prepared for a 40% turnout, but that would be very unusual, but they need to be prepared, obviously. Another question, some cases with statewide implications have been brought in Waukesha or Jefferson because the plaintiff thought he or she would succeed better there. What laws govern where cases can be brought? Krista, do you want to take that?
Yeah, so there are some cases, some of those high profile cases that have been brought in different counties concern state agencies. And so there is kind of a special statute that deals with cases brought against agencies, the Administrative Procedures Act, and that creates some opportunities to file your cases in different jurisdictions. Another is that one thing that actually is a more recent development in the law is that there can be some appellate venue shopping too. As I mentioned before, there's 4 districts for the Court of Appeals. One that's situated in Milwaukee, one that's situated in Waukesha, one that's situated in Wausau, and one that's situated in Madison. And they carry along with them a number of counties, although I think Milwaukee is just Milwaukee County. And the legislature changed the law about 5 or 10 years ago to allow certain cases where the sole defendant is the state or multiple defendants are the state to be filed in a different appellate jurisdiction than where the case was heard. So a case that arises out of Milwaukee or Madison could be heard and has to be heard actually in Waukesha or Wausau, for example. It's a pretty confusing law. It's not written extraordinarily well, but it has created the opportunity to choose not just your circuit court venue in some cases, but your appellate venue as well.
And Krista, could you give the audience a source where they can find a candidate's voting record?
In terms of like how they've voted in cases that they've decided, I'm not sure where that you could find that for the circuit court judges that are running, other than just kind of maybe doing Google searches for their names and decisions that they've issued in the past. They might be compiled on sources like Ballotopedia. I've not actually checked that, but I've used that in the past. And then Daniel Kelly's record as a Court of Appeals judge. Oh, another place you could go look is CCAP, Wisconsin Circuit Court Access Program. You can do some searches by judge, but they would have to be, you'll just get a list of all of the cases they've decided, and you can go explore those cases. And some of them are, it would be kind of a needle in the haystack finding the cases that you're interested in or that are most interesting. Then as for Justice Kelly, or Judge Dan Kelly, when he was a justice, all of his opinions would be available on the Wisconsin court website. So that's wicourts.gov. And you can search for opinions. You would want to select Supreme Court. And then I'm not sure you're able to search by author, but if you search his name within the, as a search term, you might be able to find it that way. He is also, I think some of the candidates are publicizing some of what they consider more of their high profile cases in their own campaign literature, maybe their own websites. So that might be something you could look at as well. I know that Judge Doro has really publicized the fact that she presided over the Waukesha Parade tragedy, that criminal trial in some of her ads, for example. So you can look at what their own statements are on some of those things too.
Thank you. We've run out of time. I want to thank our panelists, and you, the audience couldn't tell, but both of them are very much under the weather today, and were willing to soldier on and give us this presentation despite that. Also want to thank the League's discussion units that are going to be meeting next week to discuss the issues that were presented tonight. Information how to join a discussion unit is on our League website, lwvdanecounty.org. I also want to thank Elizabeth Caney for curating tonight's questions, and to Julia Gilden for providing technical support. The program was planned by the Court Integrity Committee headed by Janine Edwards. Thanks to Janine and the committee members Sue Jenick, Lily Crane, Elizabeth Caney, Aaron Everett, Jordan Nickel, Betty Eberly, and Mary Eberly. Amanda Hinks assisted with the resource material editing and formatting. Thanks to all of them for their hard work. Resource materials containing more information and links to organizations working on these issues can be found at our League website. I want to bring your attention to 2 future forums. A week from tomorrow, Rob will be moderating a forum for the State Democracy Research Initiative entitled Understanding Wisconsin's Supreme Court Election. You can attend in person at the UW Law School in Madison or on Zoom. You can register at statedemocracy.law.wisc.edu. And on March 9th, the League of Women Voters Dane County is hosting another in the series of forums, this one on judicial integrity. Should judges decide cases involving their major campaign contributors? You can register at our website. We also have advocacy work groups on these and other topics. Information is also on our website. Most importantly, get out and vote on February 21st and on the primary, and on April 4th. Go to myvote.wi.gov to request your absentee ballot, or to find your polling place or your early voting locations. Early voting has already started. Thanks again for your interest in our democracy, and good night.